Welcome, everybody. We're live here today. I'm Chuck Cook.
Greg Siskind.
Jeff Joseph.
And Lily Axelrod. There we go, Lily. Jump in right there. First of all, let us apologize for not being on last night at our normally date and time. I was traveling internationally. I was at an airport. I just couldn't get on, and we thought it'd be better if I think Jeff's had a massive thing to do. So it's better to have us all on if we can and answer your questions and kind of give you an update what's going on. Jeff, I want to start with the Cairo case because it literally just happened. Do you want to talk about that and maybe get some input from our folks?
Sure. I actually don't know when their answer deadline actually is. So this is the Abdul Wahed case, which is the
the banner.
Yeah. Oh, sorry.
Oh, sorry. Hold on. This is why Lily's here to remind us.
This is you about banners.
This is the Abdul Wahed v. Blinken case, which is not the K1 case. It is not the K1 case. It is the immediate relatives case, family case in Cairo. So we got an email today from the U.S. attorney telling us that of all the plaintiffs that were filed in that case, one plaintiff has been issued a visa, and all of the remaining plaintiffs, except for one, have been scheduled for interview on September 13th. So he wanted us to stay their response deadline, which is their motion to dismiss. He wants basically just to say, let's hold off on that to see what happens with these cases. So we wrote him back and said, while we agree, it doesn't make sense to brief motions to dismiss since they're scheduled for interviews. Our plaintiffs are understandably angry that those interviews are not happening until September. And so how about we stay up for 30 days instead of till September, and let's see how quickly these cases moved. And also if the consulate's willing to move them up, their interviews up. And I did let them know if they do that, we will dismiss the case. So
once the interviews take place. So.
Once they have the visa, yes.
Right. Plus we have somebody who's not on that list, who is doesn't even get the benefit in September at this point.
Right. So
exactly.
You're getting the interview now; they're set, but we want them earlier. We agree with you. That's still, if I do my math right, that's 90 days. That's still 3 months from today, and they're doing everybody on the same day. So they're telling us they literally don't have another day when they could do everybody in the next 90 days. I find that hard to believe. I just do. I find that hard to believe. We'd love to hear from you individually. If you want to email us apart, you've got our emails on that. We just want to hear from you so we can go back to the guys and say, look, you got to do it sooner. This is not good enough. It's good in that there's a date finally set, but we want it sooner because honestly, it could change too. I've read an interesting article today that the countries that got the Chinese vaccine, they're all having second waves because the vaccine wasn't any good. And so, I don't know what Egypt took, but September's not guaranteed. So let's do it now. So there we go on that. Thank you very much. Lily, I know everybody is tuned in today because they want to hear about K1 London.
Well, I appreciate the patience that it hasn't been filed yet. I had some family stuff come up this week, and my team thankfully kicked in. James Hollis and our admin folks kicked in to help me out a lot. So we've got what I think is a solid draft, and all of our colleagues are reviewing that now. So hopefully that should be ready to file shortly, and I will let you all know as soon as it is filed, and we'll send you a copy of the complaint so you can read it yourselves.
I have gone through the complaint, not in detail yet, but I've gone through it. And Lily, excellent work. It's actually tremendously good.
Thank you.
Good. And I would anticipate that'll be filed this week. I don't have any.
Plagiarized aggressively from all of our other filings, but combining all the arguments about London had the travel ban, and then they were exempt from the travel ban, and trying to explain that so the courts can understand exactly what the delay is about.
I thought it was really good. So we'll get you the details tomorrow, and I think that will be almost ready to go at that point. So we'll see then what London does. That's interesting. I do want to update folks on EB5 Fong. This is the EB5 because it looks like, I know, Greg, if you've heard, they're not going to renew EB-5 before the end of the month.
No. And there's a long history with these programs of missing the deadlines. It happens probably more than 50% of the time on the R1s and the doctor stuff in the past, and not the R1s, the religious workers. So I wouldn't surprise me at all. And obviously, I don't think that that it means the end of the regional center program, but I'm not super optimistic they're going to get their act together before the end of the month.
Yeah, I don't think the program's going to end. I mean, they're not going to walk away from billions of free money dollars every year. But on the complaint, just so you know, that it's all pending with the judge. So we're just literally waiting on the judge to make a decision whether he's going to grant the preliminary injunction, whether he's going to grant the motion to dismiss. It's entirely up to the judge at this point, and that's kind of where we stand. So just FYI, oral argument was supposed to be last week. He canceled it. And so hopefully we'll get an answer this week. There were a number of folks that texted me or DM'd me privately about Gomez Acker. There is nothing. And that's my favorite question, Greg and Jeff. What's going on? Oh, let me check. I have it right here in my secret file. I tell nobody about, and to hide it from you. Look, the moment we have any word, it'll just be everywhere. I honestly, at this point, I don't expect a decision from Judge Mehta until after the oral argument in Go.
Yeah, and don't forget that case was consolidated with several other. So there's other firms that are working on this other than ours, and there's a lot of information sources that will be out there as soon as there is any information. So. I have no doubt that the moment there's any news on that, it's going to be all over the place.
Right. You know, what's left for us in that case is the Acker. There are 12, I think there's 4 families, 12 people who just couldn't leave their country. But the key part for us, besides, making sure they get their visas, is we are trying to get a class certified so that everybody who couldn't get their visas reissued in September for a variety of reasons can get their visas reissued and are not counted against this number that Judge Mehta comes up with. That's really, really important because we don't want the Department of State saying, well, we issued the visa, they didn't use it. Well, then they should recapture those visas, but they should just give them to the people because of the short time frame created by the Department of State in not issuing visas till September. That's kind of where we are. That, of course, leads us to our Go case, which is our DV 2020 case. Jeff, Greg, there's a lot of stuff floating around on DV 2021. Rafael Reyes and Chris Morrison have a case in California that they're apparently trying to get class action status on. That's not going to have a hearing before we have a hearing in Go. And I know people want to know, well, how does that impact us? Well, it doesn't impact us. You are a plaintiff in federal litigation. And generally, when a class is certified by a federal judge, you can either join that class if you want to or not join that class if you want to. If you join the class, you're no longer in our case. If you don't join it, you're in the Go case. We believe we have an excellent judge. We believe we're in an excellent place. We believe that our plaintiffs will get their visas issued. We think that order will come down by the end of July. And no, we don't think it's affected by other class actions. And if, Judge Mehta decides he's going to limit relief to only plaintiffs, that's, personally his prerogative. Presumably the class action would cover everybody else. But I think it's important, maybe Jeff, you could weigh in on this, about being a plaintiff in a case with a positive result.
Yeah, I mean, I think, the advantage of sticking it out and staying with the case is that, if you win the case, then the judge orders specific relief. And so the judge will say, for all of the plaintiffs, this is what has to happen. This is the timeline in which it has to happen. And there will be an order that the Department of State must comply with.
Now, I think that the Department of State realizes that's going to happen. That's why they're getting even though you haven't gotten anything, they're identifying your cases so that when that order comes down rapidly, these cases will be processed. But again, for our plaintiffs, you should be reaching out to the Kentucky Consular Center either updating your data, sending your data in. You do not wait for the Kentucky consulate to contact you to send your documents in. You need to do that, and that's really, really important. And keep in mind, we are your lawyers in federal court. We are not your lawyers for your individual case, the Kentucky Consular Center, or at the actual embassy. You can hire any of our firms independently for that. But that's an entirely separate process. For us, the focus is getting you interviewed. That may be forcing the KCC to process your case and send it on over. That'll be part of the judge's order going forward. But some folks have emailed me, and I'm sure they've interviewed everybody here. I want to send a G-28 in. A G-28 is an immigration form that says, I am your lawyer. So for that particular matter. So you'd have to hire a lawyer to do that. That's the way our litigation is currently running. We are preparing for oral argument. We're preparing on the final briefing in our case. Our final brief is due on the 6th. I think the government's final brief is due this Friday. So we're waiting with bated breath to see how the government responds to our motion for summary judgment and their motion to dismiss. So I feel very confident about us, and we're in good shape on the Go case. So that's kind of where we are there. I guess this is the one I should have put up. This is the case report for the chief's process. Got way too many stuff on here. Jeff, Milligan, you have any update on Milligan?
No, I mean, cases are still moving at a clip. I think we're getting 5 or 6 a day that are getting approved. The consulates that we're seeing, Greg, you would probably know that better. What consulates are we seeing action in?
A lot of European consulates seem to be moving nicely, but they're all moving nicely except for one.
Yeah. Well, we've gotten a couple from Rio. We've gotten a couple from Stockholm. We've gotten a couple from London.
Yeah, I mean, there's one consulate that is defiant, and the rest of them seem to be reasonable on there. And the one is Manila, and I talked about that today in my Facebook Live that is the that is really our focus in terms of the problems that we're having in these, because that's the only one that there's no really rhyme or reason why that consulate in a country that never really had a COVID issue, and these are all people from round 2 on here. We're not talking about like later filed. Why that consulate has not been able to adjudicate any of those cases.
So,
and are you hearing anything? Sorry, go ahead, Chuck.
Well, we did hear that they are scheduling people again, but it's unclear how that list is being run or who they are or what order it's in.
Right. But we haven't had there's not a single visa issued so far for any of our plaintiffs out of that consulate. And that's the only consulate that we have that falls into that category at this point.
So we will, we're on top of that. Plus, of course, we do have the individual litigation against Manila, and their answer or their motion is due here shortly. Is that right, Jeff? I think that's coming up.
Right. Very, very soon. Very,
very soon. So we'll, of course, keep everybody apprised on that. And yes, we're fully aware of the nightmare that is Manila.
But I think that the separate K1 Manila case could have beneficial impact on the Milligan plaintiffs.
Absolutely.
And it's a chance for us to get a judge to hear the specific arguments about that particular consulate. And we'll use the facts from the Milligan case to basically illustrate that this consulate in particular is a problem.
So we've got that, and we've got the Rio case. We are seeing movement in Rio. They're processing our plaintiffs from this litigation. Are they going fast? No. I'm gonna give you a great example. I actually sued on an individual case, guys, on an EB-5 in Rio, and they granted an expedite in that case a week ago, but still haven't set an appointment. So I mean, this is it's weird. Should we file the PI? Should we not file the PI? It's extraordinarily frustrating. Even when they say they will expedite something for an emergency, I guess my definition of emergency is slightly different than the Department of State's definition of an emergency or an expedite. I mean, my life would be so much simpler if I used the government definition of expedite. What would feel like getting around to it? That would be kind of fun. We do have the K1 Moscow case, but I was just trying to pull that up to remember the date at which the government reply is, or government answer / motion to dismiss is due. And I just done it while we're talking here, just a little distracting to be looking that up. But it's coming up not rapidly, but in the next few weeks. The big frustration, this is true both for our K1s in Moscow, some of whom have been able to move to other consulates, but particularly for the DV 2021 folks who literally have no choice. And even in consulates where DV 2020 winners have a right to go to a different consulate, some of those consulates are denying them to come. And that's extraordinarily frustrating. But again, you document that, you copy Aaron and I, because that's all going to be in our final submission to Judge Maida to show the bad faith on the State Department's part in not making the necessary accommodations for all these visas. So,
hey Chuck, just maybe we can offer a tip or two to folks that are dealing with Moscow, trying to get their cases transferred to Warsaw. I had questions about that today in Facebook Live, but basically, the old problem that, and I understand, I had to first explain that we're not individual lawyers for these people that are moving their cases, but just in general for people that are on their own. The National Visa Center versus Consulate tug of war as far as who's to blame when they're saying that they are open to shifting the case around. And we talked about copying everybody on emails and all that, but I'm just curious as far as now that a number of months have passed with these movements of cases from one consulate to another, or this push back and forth between NVC and the consulates, if your thoughts have changed at all, or Jeff or Lily, your thoughts have changed at all as far as how you're advising people to go about trying to do that?
Well, that's a good question. I mean, the really frustrating part about this is the real inability of outside forces other than the courts to really hold the Department of State accountable. I mean, congressmen, they could have a hearing on this and say, why aren't you doing that? But they really can't hold them accountable and require them to do something, while federal courts can. And I think really the only solution, particularly for folks like in Moscow, is a federal court order, ordering them within a certain period of time to tell the court where they are going to process these people, because they are mandated to process them. And there is no doubt there's I don't know how many countries Russians can go to without a visa, but I'm sure there's 30 or 40 of them around the world, and say, look, there's got to be one or two of those that simply aren't busy. Now, is it comfortable to do that? Is it cheap? No, but if it's that or not getting a visa, do you make that necessary accommodation? That's kind of how I look at that. Mm-hmm. By the way, Ponomarenko, this is the K1 for Moscow. I just checked. It was officially served on the 5/27, which would give them until technically July 27 to get back to us on the answer, which is basically about a month from now or so. And we do not yet have a government attorney appearance in that case. Maybe it'll be Johnny Walker. I don't know. Could be. And by the way, last week we talked about Jeff reaching out to the government. And why hadn't they responded? Well, it was because of the holiday. And so they got till Monday to get something in, which I thought was really quite entertaining. I do want to talk briefly about Nunciato. It's like Gomez. We're just waiting on the judge at this point. We don't have anything from the judge on this, which I find interesting. You would think that he would, if he was going to just dismiss it, he would have done it right away. So it's interesting that we don't have a decision yet in that case. Maybe because it's tied up with other cases out there, but I don't think so. It's just interesting. Maybe the judge, who's an immigrant himself, just says, I really want to find a way to help these people. Right? Wouldn't that be a good way to go about looking at this? Kinsley. Oh, I know, Jeff. We're briefed, aren't we, in Kinsley?
Kinsley is fully briefed, summary judgment. So we're just waiting for a decision on that one.
So remind me of the judge in Kinsley. Is that Boasberg, Judge Boasberg?
Yeah, it's Judge Boasberg, assigned to the same judge as Milligan, which is very good news for us.
Right. I actually just got another case assigned to Judge Boasberg as well. He might get tired of us as part of that. Now, I do want to talk about the H-1B lottery abuse case. I am finalizing the brief, the complaint tomorrow. We will be sending it around to our team for everybody to take a look at. We plan on filing it by Thursday, and we are in the middle of drafting our preliminary injunction request, which we will file quickly after the complaint is filed in federal court. Something really interesting happened this week. We've talked about this before. When suing the USCIS, generally, you can sue where a plaintiff lives, but none of our plaintiffs live in the United States. Well, technically they do, but you can sue in D.C. And it's generally more comfortable to sue in D.C. because the government's there. And with the USCIS, they've been moving. This is really interesting. USCIS, at least part of it, is technically located in Maryland, although not all of it. And so they file a motion to change venue to Maryland. Well, this week, in a colleague of ours case, they filed in Maryland, and they moved to change the case to D.C. Now, what's great about that is we have a copy of their motion, which is awesome because, we will include that in our complaint and say, look, venue is proper here according to the government in this other case. So it should be interesting. I love when that happens. It's kind of fun to have colleagues that are just, working on this stuff. So that's in really good shape as part of that. Greg, where are we on the delayed litigation case for USCIS?
So I'm happy to report that we are going forward with that case. We have enough plaintiffs, and we are in drafting mode for
Should
that.
we just clarify what case this is in case the banner is confusing to folks? This is for folks who are applied for adjustment of status under employment-based categories, but are at risk of having the backlog be further delayed if USCIS doesn't adjudicate all of the cases this fiscal year. So
well, I know the people that are here for that case know exactly what we're talking about with that banner on there. That's I know a lot of people think about this issue a whole lot on there, and I'm excited that we're going to take this issue on, and I really want to see the government have to defend what they're going to have to defend, which is the loss of potentially 100,000 green cards, whether we win or lose. Forcing them to go and defend that policy, I think, is really critical. So we are, Chuck, I think we had said that the time frame that we were looking at for that was probably second or third week of July.
Right, because of course it's July weekends.
Filing, and that should give us the time, the government, the time, and to settle by hopefully adjudicating our plaintiff, but also to work out a solution with them, which a settlement, which will hopefully involve a reservation of all of these visas. I actually think that there are probably a number of people at USCIS and the State Department who would like to see us win on this, and would like to see us win because it solves a problem for them, which is that they may feel that they don't have the authority to do what is probably the policy that they would prefer. And a court ordering them to do it is a convenient way to get that accomplished. That's maybe wishful thinking, but I think that there's probably a fair number of people at the agency who don't like these green cards going to waste.
Yeah, and one of the things we have to force their adjudication is we'll be filing a preliminary injunction on this because there is irreparable harm, both to our plaintiffs and those coming down the line. So I think it's a question of not just filing, but actually forcing them to come to the table, forcing them to identify their lawyer, forcing them for discovery. This is what I really want to see is I want the discovery in this case. I want their internal discussions about how are we not going to lose all these visas? What are we going to do with all these visas? What's our process for getting these done? And the goal is to get our plaintiffs their visas. So if there's still time to sign up,
Chuck, I know that AILA has, through their advocacy channels, is asking for the same thing that we're asking for in the litigation, which is the reservation of these visas past September 30th. Do you think that we'll be able to get some information about the discussions on that, or they'll say that that's outside of the scope?
I think we can get any discussion that relates to the reservation or non-reservation, or the adjudication or non-adjudication of these EB cases within the fiscal year.
Yeah.
So I think we're going to get a lot of information about this. And keep in mind, we'll be putting a press release out both on this and the H-1B lottery fraud case, because this is an issue that Congress, I think, will be very interested in. Depending on which side of your eye on, our lawsuit both helps, it's designed to help tech companies, other companies that use professional skilled labor for H-1Bs, avoid this massive fraud that's going on. And I really love our complaint, by the way. Thanks to our plaintiffs, we have some great info for our complaints and great facts for our complaints. And I think Congress is going to go, wait a second, all these numbers rolled over and you didn't make any accommodation whatsoever to get these done in a reasonable time frame? You didn't lift the mandatory interview every employment-based person for the last year? So I think this is going to get some serious press here. So I'm kind of excited about that. So because I think it's going to really bring home. We have 81 comments. Hopefully we can get some replay today. Did I mention I only got 3 hours sleep on the plane last night? I don't know if I mentioned that or not. We got Like Nanat, good to see you. That is a very cute baby, by the way. Sandra Garcia, what will happen if we do not join the Jacob class action suit? Then if you're our plaintiff, then hopefully we're going to win. That's the goal. It's entirely up to you what you end up doing, or if I don't know what Jacob's class is. I have no idea what their class description is. But for our plaintiffs, we're here fighting for you to the very bitter end. What about the Rio case? Penn versus Blake, as they filed a motion to dismiss. We will respond to that motion to dismiss. I believe. I mean, I don't think there's a valid basis for a motion to dismiss.
They do that in every case too. I mean, it's not like they decided to do a motion to dismiss in this case. That's standard for litigation. So.
Which is interesting, because if you go back to a year ago, we were telling people for 30 years, look, just file the lawsuit and they'll just adjudicate the case and the case will go away. That's what they did. But they have literally, if you think we sued them a lot, we are a drop in the pond. We have been working actively with lawyers from the American Immigration Lawyer Association, teaching them how to litigate, how to do these cases. And I mean, I guess we could run a report and paste her and see, but my guess is the Department of State is sitting on hundreds, if not thousands, of mandamus actions on visas at this point. Because people saw, well, if I can't do anything else, I'm going to go to court. So they have changed, and instead of just automatically settling by adjudicating, they in some ways they're kind of like us, but they're even more so. They have a template, and we've seen the template. We see the motion to dismiss template. So it doesn't take long for the government lawyers to just file a motion to dismiss and just get it in and just trigger that clock running.
And I've seen a lot of confusion, especially from Penn, the Rio folks, but others as well, about kind of what happens next, right? The government files their motion to dismiss saying, we don't think this lawsuit is any good. That's just a request to the court. We reply explaining, no, here's why the lawsuit, is perfectly valid and why the court should do what we ask them to do. And then it's up to the judge to take a look at all of those arguments and decide whether the case will move forward or not. And then in the meantime, the State Department can keep processing visas. And we know, in some consulates, they are doing that. And in some they are not, or they're doing it only a little bit. So the timeline after the motion to dismiss depends on what the judge orders in response to those motions and whether there's an argument set. So you're confused because there isn't a clear, okay, on August 1st, this will happen. On September 1st, that will happen, right? We keep you updated on each of these suits as the next steps come up.
Sometimes it's just, and Chuck kind of gave the example of this before, that they're playing for time and they may ask for a stay. which is what happened with the Egyptian spouses, I guess.
Basically, that means a pause on the litigation. Like,
right.
Let's take a pause while we work this out.
Right. So, a lot of times this is all about, basically slowing things down so that they can deal with it through back channels and other ways to solve problems. So but the motion to dismiss, I wouldn't be worried about that because it's pretty standard, except from a timing perspective. I guess after a motion to dismiss is filed, we have the 60-day clock normally, Chuck, at the beginning. So, when they file a motion to dismiss before the 60 days, what does that do on the timing?
Well, then at that point, that's their answer to the complaint is tentatively a motion to dismiss. And this is where it's important to understand. And again, we all go to law school. We have a whole semester on civil procedure. It's hard to boil that down into a 30-second soundbite. But in order for a court to make a decision on the case, it has to have the authority to make a decision on the case, and there actually has to be a valid case. So what the government tries to do is argue, one, Mr. Court, you don't have authority in this case, or two, there is no real case here. And they do that through a motion to dismiss. And that's why that motion always takes precedent over every other motion. Because if the court doesn't have authority to make a decision in the case, it can't make a decision. It dismisses the case.
Right.
So in the strategy, we developed a little bit of a different strategy in the Go case, where we worked with the government to simultaneously allow them to file their motion to dismiss while we filed a motion for summary judgment at the same time. We will likely do that same thing in the Moscow case as soon as we identify a government lawyer that we can talk to. Because ultimately we want to get to that final judgment. Because even if we filed a preliminary injunction request, they can file a motion to dismiss, which supersedes the preliminary injunction request. Because again, you can't be a preliminary injunction if the judge doesn't have authority or if there isn't a real case in controversy. So that's kind of how this works and how we've been pursuing it in many of the cases. Sometimes the government doesn't file a motion to dismiss. Because, why wait? They're not supposed to file frivolous motions. And again, in the middle of all this, since Milligan, which was a different time, because they've changed their strategy in this latter part of 2021 so far to be more aggressive and trying to get cases kicked out and delay them. That's apparently their strategy on dealing with the backlog, delay the litigation, forcing them to expedite the backlog. It's a great strategy if you can get with it. We had like 3 questions out of 100. We're getting there. All right. Any chance for delay? No, there'll be no delay in that case. We heard. I love what this. We heard. Exactly whom did you hear this from? Consulates only give appointments on Thursdays and Fridays. Exactly who told you this? I'm just curious because Greg, have you heard that? Lily, have you heard that?
I have not. It may be that one particular consulate set a bunch of appointments on Thursday and Friday, or that they do have that policy. But there's no such thing as all consulates have a certain day. I mean, each consulate sets their own appointments in their own way. So
yeah, we talked about this before. Every consulate, and we've all learned this in our careers. At Manila is a prime example. Their own fiefdom. The consular chief is the king. And he gets to run that consular section for visas, immigrant and non-immigrant, how he or she deems fit. And that's why there's such extraordinary variation between consulates. Because the law is the same for everybody. And nobody really gets to tell the consular chief, you can't do that. Department of State runs a lot of policies, but not a lot of directives as part of this. Let's see. James Kennard. What would be the best way to get a redacted copy of Penn versus Lincoln Complete if we are plaintiff?
We can get it done. Let me just send an email to Jennifer so that she can get a redacted version.
And where are we? We're way up here. Trying to find again, this thing jumps forward when you do stuff. All right. I'm sorry if I missed your question if I jumped too far forward. Do we know anything about the UK embassies for IR tier 1s? Well, one, supposedly, it is a first priority, right? That's preference. It's the top of preference 2. I mean, what do they call those again? The 4 priorities, 4 preferences. I mean,
tiers, the tiered hierarchy.
I knew there was another related word that I was forgetting. Tiers. So tier 1 is Afghan translators, which they're doing a piss poor job of actually expediting, by the way, of a tier 1, age outs and something else. And then tier 2 are spouses of U.S. citizens and K1s. They're doing an even more job of expediting.
I think I've mentioned it on a prior call, but some intel that I had about London was that they were doing 50% time for their consular officers, and on a 3-2 schedule where it was like Monday, Wednesday, Friday for one group, Tuesday, Thursday for the other, and then they were alternating, so that they're only really at 50% capacity, and they have this massive backlog that they're dealing with as well. So it's it really is a mess, and I really do not understand why they're not at full capacity right now as far as work goes, because pretty much the UK, most people have been vaccinated. They have much higher rates of vaccination than we do, and
I put that in the London complaint, and I also did the math that the immigrant visa unit, which includes the Ks and all those IRs, they're at about 2/3 workload April of 2021 compared to April 2019. So the same month, but before the pandemic. So they're getting back up to speed. They just have a really long backlog.
Well, keep in mind this: if they just do what they were doing in 2019, they will never catch up.
Exactly.
I mean, they will never catch up. It's as like they had, again, no plan.
Right.
They have to be at 150% of April 2019 on average.
I love this. Christopher Vassa says, I work at 50% and I get all my work done. Exactly. I work mostly from home, and I'm getting as much of my work done as I can too. We're all making do.
All right, let's see. I would like to see NVC held as account. Yeah, well, I agree. The NVC is the feeder, or the KCC or the feeder to the consulates. And as far as I know, they've been working from home forever.
Right, and they're all stateside, so they don't really have the any excuses on there. None of us got to basically skip out on doing our jobs for the last year and a half.
Here's my question: since we know the NVC and KCC has been some work from home for years, why can't the consulates do it? Aren't they looking at the same stuff? Yeah. The same systems?
Yep.
Asking for a friend. I'm just asking for a friend as part of that. Let's see. Oh, I like Waleed. Good to see you, Waleed. Let's see. Yeah. Oh, Mina. Yes. So Mina, again, you can email us a little later individually about your feelings about waiting, because maybe we'll share with the government council your feelings of waiting another 3 months to join your spouses in the United States. So that would be interesting to see. Let's see. Go.
Mina, and we have asked them. So that's exactly what we asked the judge or the U.S. attorney to do today, is to see if we can get earlier dates.
So Jose Luis is having his interview. I don't know what interview, but congratulations, Jose Luis. That is awesome. And you had your medical already, so that means it'll be done by the time you go to the interview. Let's see. This is interesting because I don't understand it. Isn't Go can have a hearing after the final one? Well, is that a logic puzzle? I don't really know what that means. The final hearing on July 13th is actually the last hearing we will have in the Go case. So no, there won't be another one after that. Let's see.
We're not going to be able to get to all the questions, so maybe just skip to the ones
I am just kind of looking at the
most relevant for the most people.
Let's see. Any additional? A lot of the same questions. We answered a lot of these in our filing or in our talk a little bit earlier. Let's see. I don't know if you see anything there, Lily, that you want to bring up. Oh, it's a good question. Why can't they use other consulates in Brazil or Mexico or Canada or anywhere else? Greg, do you want to address that? How consulates are set up for immigrant and non-immigrant visas?
Yeah, so I mean, a lot of countries have their that have multiple consulates. They basically divide out different kinds of cases in different ones. So a common one would be like e-visas for investors. They have an expert in one particular consulate, and all the cases are processed there. In Canada, as an example, all the immigrant visa cases are in Montreal for the whole country, even though they have, I don't know what, like 5 or 6 U.S. consulates spread across the country on there. That's designed for efficiency in theory, but there's nothing that prevents them from being able to change things around if they want. And they've certainly had a lot of time to do that. There's also nothing that prevents them from doing adjudications by video or adjudications from within the United States. I mean, there's a million different things they could do if they wanted to, one of which is to potentially move some cases to other consulates in the country. And just because pre-pandemic they weren't adjudicating immigrant visas in those consulates doesn't mean they can't start doing that now.
Great example of that is Mexico, where all immigrant, this is the busiest consulate in the world, is in Ciudad Juarez, Mexico, right on the border with El Paso. They're the only consulate that does immigrant visas. Now, I know DFA has done in the past has done a few. Why? There's like 15 consulates in Mexico. Or 13. Why are they the only one doing it? Presumably they're staffed to do it. That would be one thing. But I love this question as a follow-up to that. Student visas. Why are they only in Rio? Why send them to Recife, send them to Manaus, send them to someplace else, and clear up space? The other answer to that is consular officers generally are assigned to non-immigrant and immigrant visas, and so they might only have 5 immigrant visa consular officers where they have 10 non-immigrant visa. Now, I'm not well versed enough in the State Department process. Why can't they just switch back and forth? I mean, they get trained on everything. So
I mean, they might make an argument that they have their panel physicians in the in the one city, and that would make why they would do it there. It doesn't make any sense for students why they couldn't do it anywhere because it's not an issue.
Yeah.
For immigrant visas, you could potentially make that argument, but it seems to me that there's how long does it take to find a physician? I mean, they've had how many months already that they could have worked it out.
This is a good question from Alina Nunciato, from our Nunciato case. We have filed a complaint with a demand that would be mandamus related, but the judge hasn't allowed that complaint to be accepted, and that's what the whole motion to dismiss is about: is whether he will allow our amended complaint to go forward on a mandamus claim, or whether he makes us refile the case as a mandamus. And I will tell you, we already told government lawyer if he dismisses it, we're going to file it as mandamus. And we will relate it to this case, and she's still going to be sitting on it. So she's doing nobody a favor by trying to get the case dismissed when, in fact, it's going to sit right back on her lap, probably back in front of the same judge. So that's kind of where we are, Lena. I hope that answers your question. Jose Luis, it's his DV interview.
DV, good.
That's awesome.
Now, somebody noted earlier that they appear to be going in date order, a number order. We know that's not true. I mean, we know it's not true. Because we see the numbers they're adjudicating as well. So now they may be reverting to date order because they, by the way, in their public statements, they keep saying that, we have to do these cases in case order, which is also not true. But it's good that you're getting it. Hopefully you have a low number. But where are the rest of the low numbers? Our plaintiffs are all over the place, and our low number folks aren't necessarily getting called in every country in the world. So, that's one of the very difficult things about this is we know for factually what they're saying is not true, and yet what they're trying to do is set up a factual scenario. Hey, Judge, we told you it was all in order, and here's why. But They're ignoring the fact that earlier in the year, they were doing them out of order. A few months ago, they were doing them out of order. Extraordinarily frustrating. I did have something that I wanted to bring up, and I see if I can find this here. I talked to our friend Britt Simon because I wanted to know how many plaintiffs there were. I mean, how many visas? Because we kept hearing, DV selectees. So here's what he told me, and I think this is actually fascinating. There were 71,926 people who were told that they've been selected in the lottery. That's the entrance. There was 71,000, but of that 71,000, there were an additional 60,000 derivatives. So that's where we're getting the 130,000 lottery selectees. There are actually only 71,000 selectees plus their derivatives. Some of the people have 5 family members, others have no family members. And it's 55,000 total people that get the visas every year. So depending on where your number is as a selectee, how many people with bigger families call in front of you, you might or might not get selected that year. But thank you, Britt Simon, for giving me the actual numbers that the State Department notified every year. And what's unclear to me, the final question about that is, so they selected 71,000 folks. Does that mean in a normal year they have 17,000 people that slough off that don't qualify, and 55,000 get it? And you have derivatives? Oh, we didn't figure those in. Or did they say, hey, we have 130,000 people, and that's usually enough to fill 55,000? That's the part of the math I don't know. But I found that really quite.
30 years of data, so I imagine that it's pretty formulaic.
Any hope in dealing with the government in the Go case? I think the alternative is, will the government agree with us? Will they settle the case by issuing the visas? Actions speak louder than words, don't you think? Clearly they have no interest in doing so.
Chuck, there's a message in there in the comments from Francine Lima, who was they were on my Facebook earlier today, and it was kind of an interesting correspondence that they got from KCC regarding Rio today on there, and I wanted to flag that. I don't know if you've seen that in the comments.
I have not. You want to talk about that?
Well, it's just that they got an email today from the NVC saying that they are no longer sending cases from the NVC to the consulate until they resume routine visa services on there. So
that'll make a really good point in the lawsuit. That seems monumentally stupid, don't you think?
I was surprised that they would put that in an email, but that's apparently what they are saying. That they are.
We have lots of emails that are in that same vein that I would, if I was the lawyer for my client, I would never let them send that out. My guess is their legal counsel for sending an email out like that. Jason thinks that we deleted a comment, but I haven't deleted any comments. So Jason, I do know that things do scroll off in the video here. So I don't know. It wasn't me.
I can only see comments. I can't actually do anything with the comments.
I'm the only one that can delete. I haven't deleted anybody. So let's see. Bernadette, go back to the first part of the video. Look for the K1 London. Lily answers your question.
The time frame to get a visa, I did not answer because that depends on a lot of things, right? It depends on generally if your case was, all ready for a visa interview in April 2020 and then got shut down by COVID, you're more likely to get an interview sooner than somebody whose I-129F petition was approved yesterday, right? In general. But each case moves, sometimes they won't go in the precise order because of, background checks that they're running or, complications in the case. And of course, it's going to depend on how the litigation goes, right? London is processing K1, so it is possible that they will informally move our plaintiffs forward. We have seen some of that with Kinsley, which isn't a mandamus case, which you might know if you're a K1 Kinsley. They have the capacity, their immigrant visa unit is open. So maybe they will start moving these cases faster the way, we're seeing in Egypt and some of our other cases. Or maybe we will see it be more like, it's not going to be like Manila, but we might see it be more like Rio, where they're processing a few cases, but not any big movement while the litigation is pending. And we have to wait for an order from the judge, which could take several months. It's a minimum of 60 days after we file that the government has to respond, or they have a maximum of 60 days to respond. And then after that, the timeline kind of depends on what the judge orders and how long the judge takes to make a decision on the fight that we might have with a motion to dismiss. So I can't tell you your visa is going to be issued by September 1st, right? The whole point of the mandamus is saying, catch up, do these quickly because you've been taking too long, but we can't give anybody a specific timeline as to when your specific visa will be issued. That's the long answer to that part of your question.
Thank you, Lily. Now, Jeff, I saw this question. I thought this is a great question for Jeff Joseph. Jeff, you want to address this because this is a really interesting kind of case.
Yeah. So first of all, there is a lawsuit. There's a number of lawsuits out there on this issue, a number of mandamus cases. And to be honest with you, the case law is not great on it. They're about 50-50 on approvals of this, mainly because the H-4 EAD is discretionary. And the cases that have failed is because work authorization ultimately is at the discretion of the Attorney General, and you cannot challenge a discretionary determination. So some of these have been successful, but to be honest with you, I think this is a really tough case to file and win.
But don't you think, the discretion is on whether they have to approve it or not on whether they can take forever to adjudicate.
That's right.
But some judges have said, look, I can't order them to issue it. And, I don't think it's been, even though people have been waiting for a year. It's an outrageous
order them to make a decision, even if it's not a favorable one.
But this goes to that whole argument. What is reasonable? And this is just really interesting. It used to be reasonable to take 3 months. It used to be reasonable to take 2 months. But why is it all of a sudden reasonable? And Greg's been big on this to take a year. Mm-hmm. Who determined that was reasonable? At a certain point, what if it takes 2 years, 3 years? Is whatever the government says reasonable? Obviously not.
And it is taking that long in the EB-5 context.
Right.
It is taking 3 or 4 years to get a green card.
Yeah. Who decided that was reasonable? That's where you have to challenge this whole issue of why does the government set that standard? They can't set that standard. And, now that we know, for example, their processing times on their website, how they put those together, thanks to the Ali Mayorkas, we can say, Judge, this is farcical. Mm-hmm. This doesn't make any sense whatsoever. So, yeah, I don't think we're not going to be putting that case on because it's very fact specific, and it doesn't really lend itself to a broader mass action context.
One other thing that I'll point out on this one is that the case that there is a big case filed by Ayla with Wasden and Baines, that there is a partial settlement on that case, in that the USCIS agreed that if you file one of these applications, you no longer have to have biometrics on a 539, right? So if you file the 539 with it, you don't have to have biometrics with it. So at least a partial victory out of this. But the rest of the case remains pending.
Of course, my comment when last month when they had the national suggestion box for USCIS, where they asked us how they can improve their services. One of my big ones was, why are you requiring EADs at all in a lot of these types of cases instead of just allowing people to use their machine readable passports and their receipts as evidence for I-9 purposes of work authorization? I still have, for my entire career, I've not been clear on why we need the EAD and what goes into an adjudication that they actually have to think about. It's virtually almost, it's almost 100% approvals for people that are in these categories that apply for it. So, that's another thing that hopefully this more open-minded USCIS will look at is, why they have some of the requirements that they have.
Greg, my answer is, when you don't know the answer, just follow the money.
Yeah.
Have you seen the breaking news, Chuck?
No, I have not.
Just got an order from Central District, California, transferring the Fong case to DC.
Well, honestly, that's not a bad thing, because that judge is probably the least disposed judge in that circuit to grant our case. 1, 2, we have a preliminary injunction pending. That means it's going to be.
That was going to be an in-person hearing in LA, correct?
Exactly. It is immediately pending a fully briefed preliminary injunction in front of the judge in Washington, D.C. immediately. So as soon as that case is, we'll follow up with the district court tomorrow, find out who is assigned in D.C. We will contact the clerk of that court and say we have now a hyper-urgent preliminary injunction pending because of a looming deadline on EB-5s. So I'm not terribly upset by that, actually. So we'll move forward. So we'll send an email alert out to our EB-5 folks tomorrow. And in some ways, this is not a bad thing, because at this point, the good thing about this is the government, and actually this will help us in other cases, the government said it should be in DC, so they can't move it from there. So now one of their tactics is now gone. And since everything else is fully briefed, it's just an oral argument. So, and maybe we'll get lucky and land in front of Judge Mehta. Part of it. All right, so that kind of ends us up for today. We're at the end of our hour here. There's some very interesting comments here. I do love you guys. Greg, do you have anything else for tonight's topic?
Tonight's topic happened. We changed our times. We're doing them at 1 o'clock Central Time now. So dinner time is free again.
That's good. That's good. Now, and Jeff, you are tomorrow at noon Central?
Yes.
2 Eastern? I am at
2 Eastern, yes. 2 Eastern, 12 Mountain.
We're going to have fun. You can watch them both because they're all recorded on Facebook and YouTube.
Next week, I'm recruiting Lily for our Facebook. Because
actually, I'm wrong.
I'm in Colorado.
Thursday at noon.
Thursday at noon. Okay. Now, I will tell all of our folks, we're actually meeting in person this week to develop more strategy. And maybe we'll even pop up a YouTube Live together. Maybe that would be kind of fun. We'll find an appropriate background setting and do that. So thank you, everybody. Lily, thank you so much. We are excited to get that filed on the K1 for London. And you can all thank Lily for that extraordinary work. And really,
and James
behind the scenes getting all this stuff done. So thank you, everybody. We'll talk to you next week or later this week. We'll let you know on the Twitter machine. Bye-bye.